See, basically, in 1861, from the times of British, that's when the modern day police evolved. That's the genesis of 1861 Police Act. That's the genesis of the today's police system in India. So today we are going to discuss a complex issue. Why I'm saying complex? Because it's a combination of technology on one end, then it is a aspect of our criminal justice system, and then both of this converge into our governance. Okay, here let me briefly explain the context of this entire bill and the issue here. For example, at a crime scene, if you find a blood sample, should we take that as a prima facie evidence, that is the preliminary evidence, or should we not? This is the question. Okay, so to handle with the investigative procedures, we have something called the Evidence Act. After the the new criminal laws were passed, the new section numbers, etc., you don't have to memorize them, but you have to know that there is something called Evidence Act. So the purpose behind this discussion is this evidence has a certain procedural aspect. So how you handle that procedure gives legitimacy to the fact that either it can be used or it can be discarded as an evidence. This is the central discussion here. What is the Supreme Court guidelines on the acceptance of DNA? That is the genetic marker, genetic material, as a proof or an evidence in crime scenes. Here the problem is anybody can put your blood sample, or anybody can tweak the evidence. So what is the evolving stance of Supreme Court, and how do we ensure that the central point here, that is whether we can treat blood samples or DNA as a evidence for a crime, what is the Supreme Court stance and how did it evolve? These are the two metrics where we will be discussing.